Mike Brown, the former FEMA director.
Joining us here is the former FEMA director.
History, I think, was very unkind to you, my friend. Very unkind.
Mr. Brown, thanks for being with us.
This is Michael Brown Unplugged.
Hey, welcome to this episode of Michael Brown Unplugged. Glad to have you with me. I want to remind everybody to be sure and vote, because in Colorado, at least, we have Proposition CC on the ballot. Proposition CC would pretty much undo Tabor, the Taxpayer Bill of Rights, and open up government spending to, well, pretty much just whatever they wanted to do. So if you haven't voted and you're listening to the podcast on Tuesday, today, November 5, you need to make sure you get your ballots in. I'd also ask you a favor. I have a poll up over on Facebook and Twitter about whether or not you are going to vote, and if you are, why, and if you are not, why. I'm really curious about this audience and all of you, and whether or not you make a decision to vote, whether you actually go out and vote, what you think about, because in my opinion, the mail-in ballots are, I'm opposed to mail-in ballots. I think it increases the options for fraud exponentially, and it kind of takes away that community that we used to have about coming together on a particular day and voting. So if you have a chance, go over to Twitter at Michael Brown USA or Facebook, Michael D. Brown, facebook.com/Michael D. Brown, and let me know about your voting and what you think about voting. We're doing a little testing, and it'd be great if you could do that for me. Now, I want to go back to 2008 when Justice Scalia, in a landmark decision called District of Columbia versus Heller, the Supreme Court held that the Second Amendment protects an individual right to keep and bear arms, and that individual right is not connected to service in a militia, and that for traditionally lawful purposes, such as self-defense within the home, the District of Columbia had a handgun ban and a requirement that lawfully owned rifles and shotguns had to be kept unloaded and disassembled or bound by some sort of trigger lock, and the court found that violated the Second Amendment. And ever since then, and I've really tried to encourage people to read the Heller decision. I know it's a Supreme Court decision, and most lay people are not really schooled in how to read those. So let me tell you how to read it. First, here's how you look it up. In your search bar of your browser, just type in District of Columbia v. Heller. Now, that will probably take you to Wikipedia, so you might type in this, 554, capital U period, capital S period, 570. So type into your search bar District of Columbia v. Heller, and then the number 554, U period, S period, as in United States, 570. And that will probably take you to Justicia. It will take you to one of the, like Cornell University. It might even take you to the U.S. Supreme Court website. But it will take you to where you can actually find the text of the opinion. And then here's how you read the opinion. There will be a lot of case citations that, there'll be a statement of law, X equals Y, whatever the law is. And then it will have a whole bunch of citations. Just skim through all of those. Skim through all of the citations and just read what the court writes. And in fact, you can even skip part of the law that the court cites besides the citations themselves, and just read through generally. If you skim through it, you'll soon find Justice Scalia giving a great historical lecture almost about the Second Amendment, and in particular, the idea about the wording of the Second Amendment, a well-regulated militia being necessary to a free state, the right of the people to keep and bear arms shall not be infringed. And that's what I want to talk about, because a well-regulated militia, what does that mean? If you're a gun control advocate, if you're one of these people that thinks that a well-regulated militia means that only a militia organized by the state can have guns, then you are woefully ignorant of not only the Heller decision, but all of the history surrounding the Second Amendment. I think that federal courts in the decades since the decision have found a lot of restrictions on the right to own and use weapons that are perfectly acceptable under the Heller decision. Now, I disagree with most of those decisions, but that's for the lawyers to argue about in court. The Heller decision merely says the government cannot enforce laws that prevent most Americans from possessing commonly used weapons in their home for self-defense. Now, let me give you an example. When I talk about courts have been finding all sorts of reasons to restrict gun ownership, here are some examples. The courts have found that Heller does not preclude laws that keep anybody younger than 21 from buying a gun in a retail store. The courts have found that laws that keep people who have committed a single nonviolent felony from ever owning a gun are lawful. They have found that laws that severely restrict the ability to carry a gun outside the home are sometimes lawful. They have found laws that ban commonly owned magazines of a certain capacity being illegal. We see that in Colorado. They have found laws that require handguns to incorporate untested, expensive, and unreliable micro-stamping technology, that having that as a requirement is sometimes lawful. And the Supreme Court so far has avoided taking up any of those questions. And I think the reason they have is, quite simply, they want to find just the right case that will, even though I think the Heller decision settled this as far as the Second Amendment being an individual right that applies to each of us individually, not a well-regulated militia. I think the court is looking for a specific case where they can address that issue and settle it once and for all. But still, when you think about what most gun control advocates do, and I hear this all the time on the radio and elsewhere, is their argument is based on the well-regulated militia clause. And they define that as a military force organized and supervised by the government. Now, outside a well-regulated militia, these gun control advocates suggest that the Second Amendment really has no practical effect that any lawmaker needs to respect. Some gun control advocates argue that the descriptor well-regulated, as part of well-regulated militia, implies that the government has this enormous power to decide who can have weapons and under what circumstances. But if you go back to the Supreme Court in the Heller decision, I think the court correctly concluded that these arguments are inconsistent with both the text and the context of the Second Amendment. All of this has to do with the structure of the Second Amendment. Let me read it to you again and explain what I mean about the structure. For example, in the First Amendment, very simply, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people peaceably to assemble and to petition the government for redress of grievances. Straightforward, no prefatory clause, no introductory clause, just straightforward, Congress shall make no law. That's the First Amendment. But then the problem is, in terms of understanding history and understanding the founders and understanding why they wrote things the way they did, you get to the Second Amendment. And instead of just saying the right of the people to keep and bear arms shall not be infringed, the founders wrote this: a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. And it is that prefatory clause, a well-regulated militia being necessary to the security of a free state, that anti-gun people have hung their hats on for decades. So let's think about the prefatory clause and the operative clause. What part of the amendment could stand alone without anything else? And that is this. That's the operative clause. What's an operative clause? Let me back up and let's talk about that for a second. An operative clause is that language which says this is what shall happen, this is what shall not happen, or this is what shall be or what shall not be. An operative clause. It's pretty simple. And the operative clause in the Second Amendment is this: the right, and let me emphasize, The other important thing to remember about the operative clause is that it can stand alone. It doesn't need a prefatory clause. It doesn't need anything before or after. This sentence is a complete sentence that could stand on its own. The right of the people to keep and bear arms shall not be infringed. Period. You really don't need anything else. So then you have to start asking yourself, well, then why is it that we have this prefatory clause that says a well-regulated militia being necessary to the security of a free state, then the right of the people to keep and bear arms shall not be infringed? Well, Justice Scalia pointed out that the amendment specifically refers to the right of the people. Now, whenever that language is used anywhere else in the Bill of Rights, just as I described in the First Amendment, Congress shall make no law, the right of the people to peaceably assemble, all of that. Or the Fourth Amendment, for example, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. Justice Scalia points out that the Second Amendment refers to the right of the people, and that when that language is used anywhere else in the Bill of Rights, just as I gave you examples in the First Amendment and the Fourth Amendment, it plainly means a right that belongs to every single individual as opposed to some sort of collective right with special properties, as in the case that people argue in the Second Amendment, a militia. A prefatory clause mentioning a purpose, Scalia argued, is not sufficient to overwhelm the simple common sense and contextual meaning of a right guaranteed to everybody. Justice Scalia said, contemporaneous usage makes it clear that the phrase bear arms cannot be restricted to a military context, which is exactly what Justice Stevens suggested in his dissent. So let's think about the relationship between a prefatory and an operative clause of the Second Amendment. You see, prefatory phrases were unusual in the Constitution, in the U.S. Constitution, but prefatory clauses in state constitutions were quite common. In state constitutions, their function can be elucidated by considering how those documents were understood. There are dozens of constitutional provisions from the founding era in state constitutions that used a similar structure to the Second Amendment. That structure is quite simple. Do you ever remember diagramming sentences in grade school or in junior high? Oh, gosh, it was the best thing I ever learned. The structure of a prefatory clause attached to an operative clause in state constitutions was quite common, and it used a similar structure. It was a prefatory clause stating a purpose, followed by a statement of the right. Some of these provisions covered freedom of speech, freedom of unjustified searches and seizures, the right to be tried for a crime in the county where the crime was committed, and most law professors would say that nobody could reasonably argue that only when a judge has concluded that exercising the right furthers the prefatory purpose does the right exist. What does that mean? You can't say that the right to keep and bear arms, or the right to free speech, or the right to be secure in your papers from unreasonable searches, that any of those inherent, God-given, and put in the Constitution written down rights can only be operative when there's a prefatory clause that has to be considered first. It makes no sense whatsoever. The right is the right is stated, and it's clear. So I think these professors are right. I don't think any judge has concluded that exercising a right furthers the prefatory purpose, and only then does the right exist. The idea that the Second Amendment only applies to people who are actively serving in a government-organized militia is based on a misreading of a 1939 case called U.S. versus Miller. And in that case, the Supreme Court upheld the prosecution of two men who had violated the National Firearms Act by transporting an unregistered sawed-off shotgun across state lines. The court said, in the absence of any evidence tending to show that possession or use of a shotgun having a barrel of less than 18 inches in length has some reasonable relationship to the preservation or efficiency of a well-regulated militia, we cannot say that the Second Amendment guarantees the right to keep and bear such an instrument. That's according to Justice James McReynolds, who wrote the unanimous opinion. Now, McReynolds was talking about the kinds of weapons covered, not the kinds of people. He repeatedly noted that the militia mentioned in the Second Amendment comprised all males physically capable of acting in concert for the common defense. In other words, he was saying that the militia was not limited to a government-supervised fighting force. It consisted of all able-bodied men. So the McReynolds decision in U.S. versus Miller is an example of how both clauses of the Second Amendment can be meaningful. And Justice McReynolds, using the prefatory clause to help settle a question raised by the operative clause without reducing it to a nullity. In other words, what arms do the people have the right to keep and bear? The type used in an organized militia. I might argue also commonly used. What's one of the most commonly used guns in America? Generically, a semi-automatic rifle, specifically an AR-15. When the Second Amendment was written, the idea that Americans had an individual right, in fact, I would even argue that Americans had an obligation. When it was written, the idea that we had a right to possess arms to defend both ourselves and the state was widely understood. When you think about the Glorious Revolution of 1688, it had roots in that revolution, rights that the American Revolution was dedicated to preserving. So let's go to 1788. Massachusetts was poised to ratify the Constitution, and Samuel Adams advocated an amendment making it clear that the Constitution shall never be construed to prevent the people of the United States who are peaceable citizens from keeping their own arms. So as they were debating that, and they were commenting on the Bill of Rights, Tench Coxe, who was a member of the Continental Congress, described the Second Amendment this way, quote, as civil rulers, not having their duty to the people before them, may attempt to tyrannize, and as military forces which must be occasionally raised to defend our country, might pervert their power to the injury of their fellow citizens. The people are confirmed by the article in their right to keep and bear their private arms. I know it's language of 1788, but what was he saying? He was saying that those that govern us, if they don't have their duty to the people before them, they could become tyrannical. And as the military forces, which must be occasionally raised to defend our country, might actually pervert the ruler's power to the injury of you and me as citizens, the people have the right and must have the right to keep and bear their private arms. Now, when the Bill of Rights was ratified, St. George Tucker, who was a professor of law at the College of William and Mary, described the Second Amendment as the true palladium of liberty. He wrote that, quote, the right to self-defense is the first law of nature, and that, quote, in most governments, it has been the study of rulers to confine the right within the narrowest limits possible. For those of you who listen to me on the radio, you know that I say time and time again that the right of self-defense is not a constitutional right. It is a law of nature. It is a God-given right. You and I have a natural right to defend ourselves against those who would steal from us or cause us bodily harm. So that tradition that tradition of making certain that those who govern us can only in the most narrow of potential ways regulate our right to keep and bear arms, is consistent with that idea that it is a law of nature. Now, that idea that the right of self-defense was a law of nature, a God-given right, was actually reflected in state constitutions that explicitly guaranteed an individual right to armed self-defense. 1790, Pennsylvania enacted a constitution that said, quote, "The right of the citizens to bear arms in defense of themselves and the state shall not be questioned." Vermont, in 1777, enacted a similar constitution, quote, "The people have a right to bear arms for the defense of themselves and the state." If you understand that in both of those instances, the framers of those state constitutions first said that the individual had a right to defend themselves, and then had a follow-on clause that said, and a right to defend the state. So where do you think the prefatory clause came from? Article 1, Section 8 of the Constitution helps clarify what the Second Amendment was all about. You see, that section, Article 1, that establishes the Congress, gives Congress the power to provide for calling forth the militia to execute the laws of the Union, suppress insurrections, and repel invasions, and to provide for organizing, arming, and disciplining the militia, and for governing such part of them as may be employed in the service of the United States, reserving to the states respectively the appointment of the officers and the authority of training the militia according to the discipline prescribed by Congress. So people that deny that the Second Amendment protects an individual right to armed self-defense start the argument with, well, it was actually meant to protect state control of militias. But Article 1, Section 8 shows the state had already lost that battle, that Congress had that power. So if you believe that the Second Amendment is just about state control of militias, that's absurd, because the Second Amendment lays out a right and a purpose contradicted by the body of the Constitution, which gives the federal government near total authority over the organized militia, the current standing Army, the national defenses, the Army, the Marines, the Air Force, the Navy, the National Guard, all of these. Scalia said in the Heller decision that under that interpretation, which of course he was rejecting, the Second Amendment protects citizens' right to use a gun in an organization from which Congress has plenary authority to exclude them, and that would make the right meaningless. In other words, if Congress has the right to establish a militia, an army, and to set forth the qualifications for you or me to be a part of that, and if that's the argument that the prefatory clause in the Second Amendment, a well-regulated militia, Justice Scalia is saying that the Second Amendment protects citizens' rights to use a gun in an organization from which Congress has plenary authority to exclude them. That would make the right to keep and bear arms meaningless. And one of the rules of construction, of construing legislation, construing a constitution, is that you have to give meaning to the words that were written. Because otherwise, you could just interpret the Constitution or a statute in any way you wanted to without regard to the words that were actually written. So the only sense in which the Second Amendment language could logically relate to those clauses, those prefatory clauses, is by saying that notwithstanding the federal government's authority over militias, the one thing it may not do is infringe on the people's right to keep and bear arms. Now, when the Senate ratified the Constitution, they actually considered and rejected a proposal that would have added for the common defense as a restriction on that right. Think about that. If you understand the history, and that's what the Supreme Court has to do, The Supreme Court has to go back and look at what was the original intent. You can find the original intent because at one point in the debate about the Second Amendment, they actually wanted to add for the common defense as a restriction on the Second Amendment and chose not to do that. When they chose not to do that, what did they do? They basically said, we're going to leave this prefatory clause in, a well-regulated militia being necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed. So what does it mean, a well-regulated militia? If you understand militias at the time of the ratification of the Constitution, the militia was you and me. And a well-organized militia was a militia that Congress or the states or somebody said, we need that to protect the state or to protect the federal government against attacks. But then it went on to say, but the right of the people to keep and bear arms shall not be infringed. The ideological background of the Second Amendment, the plain meaning of the operative clause, the parallel phrasing elsewhere in the Constitution, and the militia clauses when you go back and read Section 1 of the Constitution, make it clear that the individual has a right to keep and bear arms. And the Second Amendment, as Scalia rightly recognized, guarantees that individual right to the people, no matter how the federal government chooses to regulate the organized militia defined in Article 1. I know that's a lot to cover. That's a lot to think about. But from a legal point of view, Justice Scalia is absolutely correct. I would challenge you to do this. Go through and read the entire Bill of Rights. I know people think they know it and they understand we have the right of free speech and we have a right of being free from unreasonable searches and seizures. But if you go through and you actually read the Bill of Rights and you get all the way through, you'll go back and you'll look at the Second Amendment in a different light. And if you read Article 1 of the Constitution, where it talks about a militia, you'll understand that that's talking about the Army, that Congress has the right to organize an army. And then you'll go back and you'll realize that the operative clause, the right of the people to keep and bear arms, shall not be infringed, is what we need to pay attention to. There's your history lesson for the day. Thanks for listening. Talk to you tomorrow.